Hello, my name is Debbie Reynolds. They call me the Data Diva. Today I want to talk about data privacy and employee surveillance, or what some people call bossware. So bossware is software that companies definitely started using very heavily as a result of COVID. So people working from home, students, schooling from home. These organizations decided that they wanted to use technology to track things like people's eye movements, whether they are paying attention on the screen, track things like their keystrokes, like the frequency of them kind of leaving their computer or their desk, being able to use it for kind of test taking to watch or surveil people. Some of the issues with bossware, first of all, a lot of people don't like it. But I think employers in the U.S. Especially have enjoyed quite a long time where they could do almost anything like this and not be either called out for it or have it be something that's not against kind of a law or regulation. I think that's definitely changing. Probably two examples that I can think of is one is the Illinois BIPA, Biometric Information Privacy Act, where it's not just for employees, but sort of anyone, but employees are included in that. So employees are humans, right? So this law covers the type of notice that organizations have to give to individuals if they collect their biometrics, and also how long that data is going to be retained. We've already seen a lot of cases where companies have run afoul of BIPA in situations where, like, let's say timekeeping, and then also we're seeing, because of employee tracking, this may be one that's thrown in there as well, especially if it's about kind of people's eye tracking and things like that. Also, the new part of California CCPA that goes into effect in January 2023 gives individuals, employees in the state of California, more rights about the data that's collected on them. I think data collected on employees in these employee surveillance systems will also fall under that. So that'll be a huge wake-up call for employers that are not accustomed to giving that level of transparency. So all of this really is about data collection and data retention, and I think we're going to see, as a result of how things play out in California, you're probably going to see other laws in different states that either try to handle this situation on a kind of employee level. We're also seeing cases come out in courts around student level data collection. So having someone, for example, proctor an exam where they want someone to scan like their room and different things. And so some people have interpreted that as being against someone's Fourth Amendment rights. It's interesting to see those types of cases come up. But I think, employee bossware surveillance isn't going anywhere, but I think that employers need to be very careful about how they're using these types of surveillance technologies, and actually figuring out whether they're actually truly helpful, because not all like statistical data doesn't really tell the full story about someone's qualitative work. And I think that these types of surveillance or these types of tools are very ubiquitous, where a lot of companies want to sell these types of things, but I think organizations are going to be on the hook in terms of how they implement it, and also how much transparency that they give to employees when they're implementing these types of systems. That's it. Thank you.